The court called the case of Sarah Perkins Campbell versus James Wentworth. The purpose of the hearing was to review the father's parenting time. The session was conducted through Zoom, and both attorneys were present. Attorney Alex Mann represented the mother, and Attorney Russell Smith represented the father. Both parents were also present during the hearing. The referee had recommended that the father receive unsupervised parenting time. This would take place on the first, second, and fourth weekends of each month. The schedule would begin Friday after school and end Sunday at 6 p.m. If school was not in session, the exchange would occur at 6 p.m.
Court will call the case of Sarah Perkins Campbell versus James Wentworth. This matter is before the court this morning for the purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Alex Goldman representing the plaintiff Sarah Perkins Campbell and Attorney Russell Smith representing the defendant father James Wentworth, and both parties are present. Good morning, everyone.
Good morning, Your Honor.
Morning, Judge.
The parties have conferred with Ms. Brower from the front of the court, who has provided the court with the following recommendation: that fathers shall have unsupervised parenting time the first, second, fourth weekends of the month from Friday after school to Sunday at 6 p.m. If there's no school, the exchanges shall take place at 6 p.m. The exchanges shall take place on Sundays at Milan Police Department. The parties shall share holidays as
The recommendation also stated that Sunday exchanges would happen at the Milan Police Department. Holidays would be shared by agreement between the parents. If they could not agree, the standard friend of the court holiday schedule would apply. Another condition required that the father not take Adderall. This restriction applied specifically to him and not the child. The father agreed to this condition through his attorney. The judge then asked if both parties agreed to the recommendation. The father agreed completely. However, the mother's attorney stated that she did not fully agree.
If they cannot agree, the fallback will be the friend of the court holiday schedule. Finally, it's recommended that the court order that the defendant shall not take Adderall. This to say that minor child shall not be administered Adderall?
No, Judge, just pertains to my client.
Oh, I don't know if this court has any authority about that, but
We'd stipulate to that, Judge.
okay, all right, Mr. Smith, thank you. All right, to Mr. Goldman, does your client agree with this recommendation this morning?
Not entirely, Your Honor.
I'm sorry, I didn't catch you at the beginning of your sentence.
No.
All right, let me go to Mr. Smith. Mr. Smith, obviously your client's agree with this recommendation, is that correct?
He agrees with it, Judge, and actually what it is simply reinstating what existed prior to his parenting time being suspended. It doesn't expand the parenting time. It just puts it back to where it was. So we are in agreement.
Okay. The last order of this court entered back in September.
The father's attorney explained that the recommendation simply restored parenting time that existed before it was suspended. It did not expand his time, but only reinstated the prior schedule. The court then asked about a psychological assessment previously ordered. The father had completed an evaluation with Dr. Zubin. According to the report, the father had suffered a psychotic episode caused by long-term Adderall use. He had taken the medication as prescribed and was unaware of the potential side effects. The episode had never occurred before and had not happened again. He was no longer taking Adderall. His attorney emphasized that the father had learned from the experience.
September required defendant father to secure an assessment from Dr. Zubin Mystery. What's the status of that matter, Mr. Smith?
He did. It was a very insightful report indicating that the episode that he suffered was due to Adderall psychosis, which he was taking it as prescribed, but it was something I was not aware of, and that's the reason that we're willing to stipulate that he not be prescribed or use Adderall. This was something that he was not aware of as a possible side effect. But it's exactly what occurred, and that mirrors a psychotic episode. So he's, of course, eager not to have that happen ever again in his life. Never happened prior to, never happened afterwards, and he's on alternate medication.
Okay, so I'm not on any medication right now.
Right. So he's learned his lesson in that regard, Judge, and you can't blame him. He was taking it as prescribed. Apparently, if you take it on a long term, this is one of the known side effects.
Mr. Goldman, have you received a copy of Dr. Zubin's report?
Yes, Your Honor, and I agree with Mr. Smith's characterization of it.
And what is your, if you can expound upon your objection to this recommendation of reinstating the father's parenting time?
Certainly, Your Honor. We're glad that he's agreed to not take Adderall. Again, the psych eval suggests that that was the underlying cause of.
The mother's attorney confirmed receiving the psychological report and agreed with its findings. However, she raised additional concerns. She requested that the father undergo drug testing for 3 to 6 months. This would ensure he was not taking Adderall again. She pointed out that during his inpatient treatment, he had repeatedly asked for the medication. She also reminded the court that in earlier hearings, he denied having a psychiatric episode. At that time, he claimed he was simply searching for his dog. Because of this history, she asked the court to trust but verify through testing
of this episode. So I'm glad that he says that he's willing to not have that repeated. However, we are additionally requesting that drug testing be ordered for some period of time, 3 or 6 months, to ensure that he's not taking Adderall. The psych records from the inpatient facility that he was in show that he continued to request it daily for 8 days, saying that he didn't want his medication changed. And we know that he's lied to this court before. Over the course of several hearings, he denied that there even was a psychiatric episode. He said that he was just looking for his dog on the side of the highway. So while it's commendable that he's stating right now that he has no intention to take Adderall, we'd like to trust but verify that specific issue. So we are requesting drug testing to make sure he doesn't take Adderall. In addition, we are requesting that exchange locations be changed from the Milan Police Department to the child's school. The whole reason that the police department was stated as an exchange location was presumably because it would offer some kind of monitoring, but frequently the Milan Police Department is not actually manned by anybody, and there was an incident when Miss Campbell actually had to call the police department while at the police department, or call the police while at the police department, and it still took 10 minutes for somebody to respond. There's not actually that many cameras at the Milan Police Department. There are many more cameras at the child's school, so we are requesting that all exchanges occur at the child's school. Finally, we are requesting that instead of the previous parenting time schedule where father got the first, second, and fourth weekend, that the parties just do that he just get every other weekend. As it is, mother just doesn't have enough weekends with the minor child. And those are the changes that we would request to the recommendation.
Right. So Mr. Goldman, you're suggesting that dad take the child back to school Monday morning rather than the Milan Police Department on Sundays at 6 o'clock. There's obviously school's not open in session on Sunday evenings.
Well, it's not the issue of bringing the child to school. It's just that location has sufficient.
Right. Understood. So you're suggesting that the parenting time would be from Friday after school to school Monday morning. Is that correct?
No, Your Honor. No school drop-offs. Mr. Wentworth has had issues getting the child to school in the past.
I'm sorry, I'm misunderstanding. I thought you wanted to drive exchanges at the school as opposed to the Milan Police Department.
That's correct, but not for the purpose of the child attending school, just because there's additional video cameras at the school parking lot.
Oh, so you're suggesting that they can exchange on Sunday at 6 o'clock, but at the school, even though there's no one around?
Correct, but there's also no one around at the Milan Police Department. And there's
Gotcha. All right, okay. All right, I just say there'll be no one available to provide assistance at the schools on the Sunday at 6 o'clock.
But nor was there at the Milan Police Department. The one time that
Understood.
Very good.
It's a reasonable request. Mr. Smith, any objection to parties exchange on Sundays at what school does the child go to? Milan School?
No, Edgemont. He goes to
Elementary
Edgemont
school.
in Belleville, which is about 20 minutes farther than Milan.
Yes, Judge, and the reason that the Milan Police Department was chosen is that it's equidistant between the parties. The mother lives in Belleville, my client lives.
The mother also requested that exchanges be moved from the Milan Police Department to the child's school. She argued that the police station was not always staffed. On one occasion, she had to call for assistance and waited 10 minutes for officers to arrive. She claimed the school had more security cameras. Therefore, she believed it was a safer exchange location. Additionally, she asked that the father's schedule change to every other weekend instead of 3 weekends per month. She argued that the mother needed more weekend time with the child. These were the requested modifications.
in Petersburg, and he has picked the child up from school and has no objection to that. But it was thought to eliminate some of his drive time, that the Milan Police Department would be a good exchange. There's no real reason to change that. There's no additional security at the school. We'd ask that the prior order remain as written, Judge. And as far as Mrs. or mother not having time with the child, she has the child each week, every week. And this was something that was agreed to prior, and there's no reason on earth that my client's parenting time should be lessened. He, because of this incident, of course, was parenting time was suspended for quite a few months, and he's eager to reinstate that, Judge.
Okay, what about the drug testing, Mr. Smith? Any objection to that your client submit to weekly drug testing, providing the results?
Well, it would be a financial burden to him to do that. I don't see any real reason for it. And
I'm trying to catch up on my support right now, so any more expenses aren't going to help that.
And believe me, Judge, my client was so frightened regarding this incident. He has no intention of ever taking that drug again. So I believe that the prescription in the order ordering him that he not take that drug would be sufficient.
Right. Mr. Coleman, would your client be willing to pay for the drug testing?
No, Your Honor.
All right. The court would order it if the plaintiff is willing to pay for it, but if she's not willing to pay it, the court would not order drug testing. Obviously, if there's an issue with Mr. Wentworth's behavior, then we require immediate hair follicle drug testing to see if he's back taking Adderall. All right, at this point in time, the court will in fact adopt the recommendation of Ms. Brower. Father shall have unsupervised parenting time first, second, fourth weekends from Friday from school to Sunday at 6 p.m. If no school, exchange will be at 6 p.m. and the party shall exchange on Sundays at the Milan Police Department. If Ms. Campbell is concerned about her safety, she can bring in someone with her. And if there's an incident, she can.
The father's attorney objected to changing the exchange location. He explained that the Milan Police Department was chosen because it was halfway between both homes. The mother lived in Belleville, and the father lived in Petersburg. Changing the location would increase the father's driving time. He also argued that there was no clear evidence the school offered better security. Regarding the weekend schedule, he stated that the mother already had the child during the week. The father's time had been suspended for months due to the incident. He was eager to rebuild his relationship. There was no valid reason to reduce his time further.
Obviously call 911. If there is an incident, then the court would without question modify that to provide for a more secure place for the exchanges. Hopefully it will not be an issue. Mr. Wentworth, you've got somewhat of a history, so obviously you need to be on the best behavior.
Well, believe me, Your Honor, I'm not going to do anything to change what the progress we've made. And I'm just looking forward to being a father again.
Well, but we want you to be well. So I don't know if are you still involved in any type of therapy, counseling?
I speak with a life coach. I try to do it every week, or like every other week right now. But I'm doing everything I can to stay on the right track.
All right. Well, that's critical, Mr. Wentworth. Obviously, the court, your past behavior has been of significant concern to this court. Hard to believe that could be Adderall, but if that's what Dr. Mystery suggests is the result of that, then so be it. I mean, so Mr. Wentworth is previously diagnosed as acute psychosis. And Dr. Mystery is suggesting it's caused by Adderall. Is that correct, Mr. Smith?
Yeah, it's a psychotic reaction to long-term Adderall use.
All right. Well, it shall be discontinued. And if there's issues, then we can address it at that time. Hopefully there will not be. So we need to get things back on track. Mr. Coleman, obviously, if there's any unusual behavior on the part of Mr. Wentworth, bring that back before the court's attention. We'll address it.
Very good, Your Honor.
Thank you, Judge.
So when will this start?
This weekend would be great.
This weekend, Your Honor, is it your scheduled weekend?
Yes.
Yes.
It's the first weekend, first, second, fourth weekends. All right. With that, the court will adopt the recommendation. That will conclude this hearing. Everyone can zoom out. Have a good rest of
Thank
the
you, Your
morning.
Honor. Thank you, Ms.
Welcome.
Brower, for your
Thank you, Your
time.
Honor.
Thank you.
Calling the matter of David Show versus Amanda Branshaw.
The record, this matter is before the court for the purpose of reviewing plaintiff father's parenting time and any other issues. The hearing is being conducted via Zoom. Present is Attorney Amber Billmeyer. Good morning, Ms. Billmeyer. I'm glad you're still hanging in there.
Good morning, Your Honor. Thank you.
And with Ms. Billmeyer this morning is the plaintiff father, David Show. In addition, Attorney Christina Hillis is present representing defendant. The mother, Amanda Branshaw. Ms. Branshaw is also present. Good morning, everyone. Good morning, Ms. Hillis.
Morning, Your Honor.
The court then addressed the request for drug testing. The father's attorney argued that weekly testing would be a financial burden. The father was already trying to catch up on child support payments. He insisted that the father had no intention of ever taking Adderall again. The father himself expressed fear about repeating the past incident. The judge asked whether the mother would be willing to pay for the drug testing. She declined. As a result, the court decided not to order testing unless she agreed to cover the cost. However, the judge warned that any concerning behavior could lead to immediate testing in the future.
Parties have conferred with Ms. Pratt this morning. One moment and I will share her recommendation. Mr. Pratt is recommending the following, that all motions are dismissed without prejudice. It's not clear what motions are being referred to. I thought the only issue was just simply reviewing parenting time. Ms. Billmeyer?
We did have a motion for, I believe, a change in custody and parenting time, and we are going to dismiss that. I thought Stephanie had filed something as well, but I could be wrong. I'm Christina, not Stephanie. But the parties are working with Dr. Drescher on all aspects of parenting issues, and she thinks that this is a course they can navigate on their own. And the clients.
Wonderful. That was a motion filed some time ago, and that's been pending, correct?
That is correct.
Okay.
And per Dr. Drescher, the parties are making very positive progress.
Wonderful. So is that the only motion that is pending and needs to be addressed? Because I'm going to have Mr.
The judge ultimately adopted the referee's recommendation. The father would have parenting time on the first, second, and fourth weekends from Friday after school until Sunday at 6 p.m. Exchanges would remain at the Milan Police Department. If the mother felt unsafe, she could bring someone with her. In case of any incident, she could call emergency services. The judge reminded the father that he had a concerning history and must remain on his best behavior. The father assured the court he wanted to move forward positively. He confirmed he was working with a life coach regularly. The court stressed the importance of continued support and stability.
Brad specify that the plaintiff's motion to modify custody is being dismissed without prejudice. Are there other motions pending?
I was just looking through my file. I did not recall, we've been reviewing this for a while, obviously. I did not recall filing any motions. So I don't believe we did. Wait, hold on. Right now.
Okay.
Well, it's certainly good news. Good news to hear that Dr. Drescher is helping.
We did have a motion to modify parenting time as well, Your Honor. I misspoke. That was back, looks like it was filed back in January of 23.
I also think perhaps, Christina, that you filed a motion because there was some medical issues. Parents were disputing who could schedule, but that would have been pretty far back.
So we can simply say that all pending motions, including but not limited to plaintiff's motion to modify custody and defense motion to modify parenting time are withdrawn or dismissed without prejudice. Would that be accurate?
I believe that's accurate and satisfactory.
Yes.
Wonderful. Do we need to put this back in the court's docket? Obviously, the courts want nothing more than to see.
The next case involved David Show versus Amanda Branch. This matter also concerned parenting time and prior motions. Both parties were working with Dr. Dresser to improve co-parenting issues. Several pending motions, including requests to modify custody and parenting time, were discussed. The attorneys agreed to dismiss all pending motions without prejudice. Dr. Dresser reported that the parents were making positive progress. She recommended taking a break from court proceedings to reduce stress. The judge supported this approach. The court emphasized its interest in helping children maintain relationships with both parents. The matter was concluded without scheduling another review hearing.
That the children develop a relationship with dad, most importantly, but obviously maintain a relationship with mom. Any reason to put this back in the court's docket? Otherwise, you can always notice it back.
Dr. Drescher actually recommended against that at this time, having another review hearing because of the stress that it was creating. So we would ask that, and that's knowing the court has every good intention in moving this forward. But her recommendation was that we take a bit of a break from the court proceedings. And given her perspective that things are going very positive at this point, that Cole and Dad are working on the relationship and developing a roadmap, at least for some for contact moving forward. I think the parties can work through that on their own with Dr. Drescher, and of course, either party in the future would be able to file whatever they feel is necessary to bring this back to the court's attention.
Absolutely. That makes imminent sense, Ms. Sills and Ms. Billmeyer. The court certainly does not want to agitate things by putting it back on its docket. The court simply has a sincere interest in seeing children develop a relationship with each parent, with both parents. And you would agree with that then, Ms. Billmeyer?
Yes.
Wonderful, wonderful. All right. The court's going to have Ms. Pratt, when she's available, just to modify the rec to specify the motions that are pending, that are withdrawn, that are dismissed without prejudice, and that will conclude this matter. So everyone can zoom out and have a good rest of the morning.
All right, thank you, Your Honor, you too.
Thank you.
Matter of Lauren Fuller versus Derek Fuller.
For the record, this matter is before the court and the plaintiff. The mother's object to a referee recommend order of child support. This hearing is being conducted via Zoom. It appears both parties are present, Lauren Fulner and Derek Fulner. Good morning, everyone.
Good morning.
Good morning.
The two of you have conferred with Ms. Patrick, our friend of the court, who's provided the court with fine recommendation. The recommendation is that the referee recommend order be adopted but modified, namely child support shall be in the amount of $1,505 per month commencing September 1st, 2024, as opposed to the $1,381 for the three children. Ms. Fulner, do you understand the recommendation and do you have any objection?
I do understand and I'm okay with it.
Okay, Mr. Fulner, do you understand the recommendation?
Yes, I do.
Mr. Fulner, do you understand the recommendation this morning?
Yes, I do.
Okay, do you have any objection to the court adopting this recommendation?
Nope.
Right. Obviously, if your income drops or some modification, you can always petition the court to modify child support in the future. So the court this time, since there's agreement, the court will adopt the recommendation of Ms. Patrick, $1,505 per month, and that will be effective September 1st of 2024. So that's when Ms. Fulner originally filed her motion back in September. All right, so that will conclude this hearing. You can both zoom out. A copy of these orders will be mailed to both of you.
The final case involved Lauren Fulner and Derek Fulner regarding child support. The mother had objected to a referee's recommendation. After discussion with a friend of the court representative, both parties agreed to a modified support amount. The new amount was set at $1,505 per month for 3 children. This would begin on September 1st, 2024. Both parents confirmed they understood and had no objections. The judge reminded them that future changes in income could justify modification. The recommendation was officially adopted by the court. Copies of the order would be mailed to both parties. The hearing was then concluded.